Morning.
Good morning. Good morning, Prof.
Morning, sir.
Morning, Prof.
Good morning, everybody. How are you this morning?
Very good, Prof. How are you?
Good, good. Great to see you again.
Great to see you as well, Prof.
Okay. We have discussed about the sources of law, but we have to continue it. We have to continue discussing sources of law. Okay. Now I tell you the sources of law, acts and regulation. I guess when you learned an introduction to Indonesian law, I've explained about the sources of Indonesian law, but I think it is not a specific state. It is in general. Case law, agreements, best practices. This is my idea that best practices are also considered to be sources of law. We begin with acts and regulations. Okay, I guess it will be better if we have to be consistent. If it is this plural, it is a plural. Or if it is singular, I guess it would be better that singular. Act is made by the parliament of a state. In the parliamentary system, the parliament is the House of Representatives. But there are two types of parliaments. It is in Latin, it is bicameral and monocameral, like in the Netherlands. The parliament consists of what they call Eerste Kamer and Tweede Kamer. Sorry, there's something smell. Well, it's bad, not bad smell, but it is not. Well, my immunity defends something that comes into my nostril. If you sneeze, for example, I think it is to defend your body from virus or any bacteria. And bacteria. Act is made by Parliament of a state. In the Netherlands, parliament consists of Eerste Kamer, of if it is translated into English, first house, and Tweede Kamer, the second house, or we call them as lower house and upper house. In United Kingdoms, the parliament consists of House of Commons and House of Lords. In the United States, it is different. Congress is the agency that is charged of making law. Congress consists of the House of Representatives, who are elected by the people, and also the Senates, who are representative of a state, of every state, but they are also elected by the people. Okay. So act is made by the parliament of the state. Regulation is an authoritative rule issued by executive power to implement act. Why in France at the time, it is in the antecedent of France Revolution 1789 of July 14th, 1789. It was a French Revolution. At the time that there's this doctrine that act is a product of parliament, means that act is a product of general will, which cannot be defeated by judge, and then there was a doctrine of legality principle, by which that judge may neither interpret nor deviate act. So this is the idea why there was a principle of legality at the time. But principle of legality in criminal law was developed by Anselm von Feuerbach, Austrian scholar. In civil system, act and regulation are the primary sources of law. Civil system is adapted by continental European states. The Netherlands, Italy, France, Belgium, Spain, Portugal, Germany, What else? European countries. They adopt civil system, which is derived from Roman law. On the contrary, in common law system, which is adopted in England and Great Britain and its colonies, including Singapore, Malaysia, India, Egypt, Australia, United States, New Zealand. What else? They adopt common law system. You know, state gazettes. In civil law tradition, once a bill approved by the parliament, it is enacted as law, but is not publicly recognized. You know, it's old man, you know, use this. It is seen from the video that I have to do that. It's okay, no problem. It is sorry. It is mandatory that law be promulgated through state gazettes. It is mandatory that law be promulgated through state gazette. Once a law is promulgated through state gazettes, it is assumed that everybody knows the law, or in Latin it is called presumptio juris et jure, which is translated into English: ignorance of law is no excuse. Ignorance of law is no excuse. Bimo, Bimo Prakoso. Bimo.
Yes, sir.
Yeah. Do you know Act number 11 of 2009?
Yes.
Do you know that?
Yeah. But like,
What is it?
but I don't remember the. I don't remember the substance. The substance.
Okay.
Yeah.
But do you know? If you don't know, you presume. Sorry, you presume to know it. So everybody is presumed to know the law when it is promulgated through the state gazette, even though he or she really doesn't know that. Okay, don't worry. I don't know either. I didn't know either. But I have, but I have to comply with the law because it is assumed or presumed that I know the law. The effective date of a law. Not every law is in effect as soon as it is put in the state gazette. Not every law is in effect as soon as it is put in the state gazette. The date when the law begins effective is stated in the law alone. In fact, it is in reality, most laws begin effective since the date of promulgation. But it is stated in the law. It is stated in law that its effective date since the date of promulgation. Okay. Well, it is stated in the law that its effective date begins since the date of promulgation. Some laws, however, begin effective in a proper time after promulgation as they specified. So, as I've told you before, that the law itself that states or specifies when it begins effective. In addition, there may be a law which is called a retroactive or retrospective law. What is it? The law is declared effective prior to its promulgation. The retroactive or retrospective law is the law that is declared effective before its promulgation. It is stated by the law itself. If the law states nothing about when it begins effective, it is considered to be enforced 30 days after its promulgation. You know the other words of enforce. It is going to be applicable to be in power. Well, so I use many words which are similar, which are synonyms to make you what I say, to avoid you getting bored to read my presentation. So many vocabularies are used to avoid getting bored, getting bored for the leader, for a reader. This is the retrospective law. Well, it is the former definition of retrospective law. This law looks backward or contemplates in the past, which may affect acts or facts occurring or rights accruing before it is put in the state gazette. This law looks backward, look back or look turn around like that. Look backward or contemplates in the past, which may affect acts or facts occurring or rights accruing before it is put in the state gazette. Well, I think I'm glad if a ministerial decree that increases my salary, our salary, and it is retrospective. For example, this decree begins effective since January 2018. Well, it's good. Now, December 2020, for example, and we get so accruing because it is put in the state gazette. We may get a lot of money on it if it is salary increasing. I want to ask you about this word. What's the difference? Gisela, effect and effect.
Effect is causal, the one with the A. Like A is to create impact, and effect with the E is the result of a change.
Okay. You some, the difference between effect and effect.
Yes, I do have the same opinion as Gisela. So effect is the doing word, and then effect is the result of the effect. If you
Okay. So effect is a verb. It's a verb. Effect is a noun. Okay. Effect means to make effect. Yes. This is a verb. And it is a noun. Effective is an adjective. Okay. Effective is an adjective. Affection is all noun, but it's different meaning. Affection, like affection, emotion, deals with emotion, affection. But effect is a verb. Effect is a noun. Effect is a consequence, right? Okay. Okay, we go back. Unless it is carefully enacted, it may cause legal uncertainty. So the retrospective law should be enacted carefully, very careful. Otherwise, it may cause legal uncertainty, and it may cause disruption, perhaps. Criminal provision may not be retrospective due to legality principle. Criminal provision may not be retrospective due to legality principle. So there's no criminal provision that is retrospective. Yeah, because legality principle is held firmly in a criminal law. Now, hierarchy of laws. Please keep in your mind that it is hierarchy of laws. It's not hierarchy of norms. It is hierarchy of laws. Constitution, I think, is the supreme law. Constitution is the supreme law. Constitution is a basic law. And any provisionary statutory provision, any statutory provision should not be inconsistent with the Constitution. Any statutory provision should be consistent with any provision of Constitution. Otherwise, it is declared invalid. Regulation. Now, presidential, still remember that? Lex superior derogat legi inferiori. Lex superior derogat legi inferiori. Superior law supersedes inferior law. Act and regulation. Regulation should be regulation should comply with the law, with the act. Act is superior to government regulation. There's lex specialis derogat legi generali. Special law supersedes general law. Lex posterior derogat legi priori. posterior law supersedes prior law. Both laws are at the same rank. This one, both laws are also in the same rank. In this case, both laws provide the same subject matter, the same law, or law concerning the same subject matter. For example, law concerning government, regional government, for example, law concerning regional government. The old law is superseded by the new law. Okay. Now, case law. Still remember res judicata? Res judicata?
Yes, sir.
Okay. Res judicata means that the judgment or the decision may not be appealable anymore. Decision, the judgment may not be appealable anymore. Case law become a source of law because once a decision is res judicata, it may be applied to settle similar cases. This is a good case. A good case, or it is about Todd. Don't know who V. Stevenson. The case was in England, I guess. On April 9th, 1929, Mrs. Mary Alistair O'Donoghue brought an action against David Stevenson, edited water manufacturer Paisley. You know, edited water? Like soda water. Like soda water. Yes, one sterling. It was in England. She claimed 500 pounds sterling as damages for injuries sustained by her through drinking ginger beer, which had been manufactured by the defendant. You know ginger beer?
Yes, sir.
Yeah. When I was in the United States, I liked ginger beer, but there's no ginger in it. Like ginger beer, but there's no ginger in it. Like root beer, have you drunk root beer? Root beer, if you go to A&W American restaurant, you can order root beer, but there's no beer. root beer is not beer. It is soft drink. You know, it is soft drink. It's not liquor. You know liquor? Liquor, whiskey is liquor.
Yes, sir.
Alcohol.
Liquor, well, I don't drink liquor.
Liquor is the same as alcohol, right, sir?
Yeah, alcoholic beverage. Alcoholic beverage. Beer is also, but beer I think is not considered to be liquor, even though our beer is alcoholic. But if you drink root beer, you don't taste alcohol in it, because root beer is not beer. Root beer is not beer. Ginger beer in the United States is not beer either. It's nice, like soda water, ginger beer. I also like root beer because it is not beer. It's not Heineken or Bintang beer or Anchor. You know, it is root beer. You can go to a NW and you order root beer and then you drink. When I was a child, sorry, the taste seems to be sarsaparilla. This root beer. She claimed 500 pounds sterling as damages. You know, damages and compensation is different. If your house is demolished, for example, by the municipality or mayoralty, you can get compensation. But damages is different. It's not compensation. This is a story. This story. Mrs. Donoghue and her friend went to a shop occupied by Francis Minchella and known as Meadow Cafe. Cafe. Don't read cave. Cafe. At Meadow Place, Isley, where the friend purchased ice cream and the beer suitable to be used with the ice cream as an ice drink. It's very nice, of course. Of course, it is because ice cream and ginger beer, like in Indonesia, we call it cream soda. Cream soda. But now there's a soda gembira. Soda gembira. Milk and soda water. Milk and soda water and sugar. It is called soda gembira. Happy soda. Glad soda. Well, this is ice cream and soda water and ginger beer. It is very nice, of course. So Mrs. Donahue and her friend went to a shop occupied by Francis Michela and known as Meadow Cafe. Bon Cafe. Don't say Bon Cave. No. It is France. Cafe is France. Also restaurant. Restaurant. It's not English. Restaurant. But in the United States it's called restaurant. But really it is restaurant. Restaurant, cafe, cafeteria in the United States. It's called cafeteria, but we call it cafe, not cave. Where friend purchased ice cream and ginger beer suitable to be used with the ice cream as an ice drink. The ginger beer was contained in an opaque bottle that prevented the contents from being viewed clearly. Well, I don't have opaque bottle. Dark. This is clear, bright. But opaque bottle, for example, the dark. Let me find if there's a opaque bottle. Ada botol yang gelap. Ada ini. Ini loh. Apa ini? Yang gelap lah ini. Opaque bottle. This is opaque bottle. So you cannot see what inside it is. What inside is opaque bottle.
It's like a medicine, sir. Yeah.
Yes, this medicine, but it is not clear what kind of medicine. Okay,
Cough medicine.
this opaque means dark like this. Okay. The ginger beer was contained in an opaque bottle that prevented the contents from being viewed clearly. If this one can be seen, what is inside? Chili sauce. Chili sauce. You know, chili sauce. You can see what is inside. Okay. Mrs. Donahue consumed some of their products after which the decomposed remains of snail, you know, snail,
Yes.
sorry, emerged from the bottle when the remaining ginger beer was poured into her glass. The snail. It's true. This is the real story. This is the real case. It's not my my imagination. No. So
Sir.
Mr. Donahue consumed some of the product after which the decomposed remains of snail emerged from the bottle when the remaining ginger beer was poured into her glass.
So she ate the snail?
Sorry?
Did she ate the snail?
Snail, the combo snail.
She
You know
ate.
snail?
Yes, she ate it.
Well, no,
No.
she drank. She drank.
Okay, okay.
Sorry. Sorry. It is in the bottle. In the ginger beer bottle. There was snail. If you were C, what will you do? Aura.
I'll be shocked, of course. I think I'll be more speechless, I guess.
She, she saw damages against the manufacturer Stephen from the resulting nervous shock, nervous shock and gastroenteritis. Gastroenteritis, stomach ache, which she claimed was caused through the incident. I think because she was nervous shock. Disgusting, disgusting.
It's really disgusting.
Very disgusting. Seriously disgusting. Uh, she saw damages against the manufacturer Stephenson for resulting nervous shock and and this is gastroenteritis. I think it is an effect. An effect of the shock. But I think the the snail did not affect because it was in the alcoholic beverage and nothing to do with the gastroenteritis, but because she was shocked.
Sir, how does
Yes.
the snail get into the bottle? How does
Sorry?
this? How does,
This is the problem
Mm.
because I think the ginger beer was bottled by the factory. Like when I saw the Bintang at the time, I saw how topping the bottle with what is the that this one there's a what is it, conveyor, and it is automatic. Perhaps the snail went to the bottle before the bottle was conveyed by the conveyor at the time, because it is automatic. I don't know. Perhaps the producer didn't know either. But it is the incident. Court decision. The trial judge found that the plaintiff could bring an action. Okay. So plaintiff is eligible to bring the lawsuit. The Court of Appeal overturned this decision. As I've told you previously that it is automatic. So I think to to borrow, it is not done by the producer, by the shop holder. Why not to the Supreme Court? At that time, United Kingdoms had no Supreme Court. I guess only 2009. I guess there's a Supreme Court in the United Kingdoms. At that time, the House of Lords is the Supreme Court. So there's no separation power in Great Britain. The legal issue before the House of Lords. This is interesting. It is about tort. Whether the defendant Stevenson or Mrs. Dono a duty of care. Please keep in your mind that tort in common law system consists of negligence. Negligence means that you may hurt someone without your intention. Negligence. So you may make someone else harmful without your intention. It is negligence. Trespass. Trespass means you make someone else hurt with your intention. That is duty of care means that you don't keep the duty of care. This is Lord Atkin. The complainant means the complainant in the petitioner, plaintiff, complainant, petitioner. The complainant has to show that he has been injured by the breach of duty owed to him in the circumstances by the defendant to take reasonable care to avoid such injury. This is the opinion of Lord Atkin. That is now is also held by some court decision. Not every moral wrong can have a practical effect effect in law, so it must be limited to taking reasonable care to avoid acts or omission which you can reasonably foresee would be likely to injure your neighbor. It is English neighbor, with you. If American English, without you, like color, without you. A neighbor is a person so closely connected with you, with and directly affected by my act or omission that I should have had them in mind when I committed the act. So you have to make prediction. If I do that, it will hurt another, it will injure another. This is the you have keep in mind to do that. So as many as possible, you should avoid doing that. You should avoid doing that. Otherwise, you're declared as committing against the duty of care. It would be grave defect in the law if a consumer could not claim in circumstances such as manifestly negligently mixing poison into a drink. And in 1980 something, I guess, in Indonesia, there was a poisoned biscuit case. Poisoned biscuit case. You know, biscuit. I don't know the trademark, but it is inconsiderate if I tell you the trademark. But it was the case in Indonesia that those who consumed the biscuit, several people who consumed the biscuit died at that time because the biscuit was mixed with poison. Was the manufacturer or producer liable? Sure. At the time. Was it murder? No. Okay. So the producer should be careful to produce the what is, whether it is food or beverage. The essence of Lord Keynes' opinion. Lord Keynes' statement about the foreseeability of the effect of one's act on one's neighbors is central to the existence of a duty of care in the law of tort or delict, especially on the then developing nascent tort delict of negligence. Delict. Please be careful. In Dutch, delict deals always be with criminal act, delict in Dutch, but delict in English deals either with civil or criminal act, delict, because it comes from Latin delictum. In Latin, delictum deals with both criminal and civil acts. in his judgment, he formulates what is commonly known as neighbor principle. This is a judgment. Who then in law is my neighbor? The answer seems to be persons who are so closely and directly affected by my act that I ought reasonably to have them in contemplation as long as so affected when I am directing my mind to the acts or omission that are called in question. So if you are sorry, you are a businessman or business people that that as a core business core is restaurant. So you have to know, you have to be careful on that because your consumer is your neighbor. You have to take care of your consumer. Okay. So in my book, I wrote that there's also a case between consumer and Coca-Cola company. Why? Because Coca-Cola company at that time ignores um, to cover the floor, and then the consumer fell down to the basement. This is the neighbor. Now, agreement and case law. Agreement. A concord of understanding and intention between two or more parties with respect to the effect upon their relative rights and duties that have been mutually consented. So a concord of understanding and intention between two or more parties with respect to the effect upon that. The issue is whether or not the parties to the agreement are equal. So they have equal position in the agreement. No, no, not really. I will tell you this way. If in agreement, two parties are in equal position, both duties and rights are equal, but it is real if both parties are in unequal position. Unequal. Unequal, in um unequal, that the noun is inequality. It is adjective, it is the noun. Please be careful. Why it is like that, I don't know. It is English. It is English. Why there are irregular verbs, irregular plurals? Ox becomes oxen, not oxes. I don't know. It is English. And I think in every language we find some irregularities. If both parties are in unequal position, there should be inequality. But in my mind and in my idea, and it has been written as a dissertation by my candidate at the time. Now he's been professor. Whatever the position of the parties, that should be equitability. Equitable. Sorry. Equitability. In an agreement, frequently it is equitability in some clauses, because in agreement it is frequent that the both parties are unequal position. For example, customers and banks, for example, whose position is stronger than whose position is stronger of each other. The consumer or the bank is stronger to another than another. A bank and a customer who has stronger position. Razan. Hey Razan, where are you now?
I'm at my house.
Oh yeah, you are at your house. But who is stronger? The customer position or bank position?
Customer or what?
In loan agreement, for example.
Mhm.
For example, you want to borrow money from the bank, and there's a collateral. Your collateral is your title of your car, for example.
Okay.
You know, title of your car.
Yes, I know.
Title, if the title of your car is made as collateral, and you get money from the bank, and there's an agreement between you and the bank. Which one is stronger than another? Your position or bank's position? Lazam.
I think the bank is more in a better position than I am. I think.
So the bank has stronger position than you are.
Yes.
Well, okay. Right. It is in the agreement clause. It is right. Before the loan is dispersed. Before the loan is dispersed. But after the loan is dispersed, your position is stronger than bank's position. Why? Why? If you don't repay, the bank can only what I say, dispose of your car, but only the title. The title. Okay. This is bank throughout the world doesn't want you to sell the collateral. What banks want is to get back its money. Of course, in agreement, your position is weaker than bank's position. But in reality, if the loan is dispersed, the bank's position is weaker than yours. Okay. This is banking. So, well, in unequal position, that should be equitability. It is not equal, but equitable means that the stronger party does not exploit the weaker party with laying down clauses that make the stronger party I see there's no exploitation. I mean that in equitability principle, there's no exploitation made by the stronger party to the weaker party. So there should be reasonable clauses. Okay, equitability. It's not equal but equitable. For example, McDonald, United States. Do you know McDonald? McDonald? Yeah. Have you ever visited McDonald?
Of course.
Yes. Because Surabaya, Jakarta, even in a small city now, in small city in Indonesia, there are McDonald McDonald outlets. I don't know whether in Ponorogo there's a McDonald or not. But in Madiun, I think there's a McDonald. Okay. I know the agreement of McDonald, but I cannot disclose it because it is confidential. At that time, it was shown to me by one of its lawyers, because I want to know about the position of Indonesian McDonald's and American McDonald's. Now McDonald's is in Indonesia. Indonesian McDonald's is held by Teh Botol Sosro, I guess. At that time, the licensee was Bambang Rahmadi. You know, it is stated in an agreement, in a contract, that 70% of profit of each unit goes back to McDonald's. Only 30% of its profit goes back to Bambang Rahmadi at that time, to Indonesian McDonald's. Is it equal? No. No. But it is equitable. Is it fair? Is it just? Yes. Why? Because American McDonald has spent a lot of money to establish to establish its name, to establish its trademark. But Indonesian McDonald only licenses the the trademark and gets a lot of money from the licensed trademark. So it is equitable and it's just, it's fair. Okay? Equitability is a kind of justice. So after calculated by the accountant, then the accountant approved the distribution of profit. Okay. This is equitability. It's not equality. The parties to the agreement may be natural person or legal entities, also called legal person, organization with certain qualification treated as if they are natural person. Sorry. Legal persons, for example, in Indonesia, under Indonesian law, legal persons are limited liability company, limited liability company, PT, foundation, foundation is established for charity. That company is established for getting profit. Okay. Company is established for getting profit. Foundation is established for charity. And the third is cooperatives. You know, the purpose of cooperative is to increase the members' welfare. But the cooperatives also seek profit. You know, cooperative. You know, for example, cooperative saving and loans. You know, saving and loan, savings and loan, cooperative savings and loans. It seems to be a bank, savings and loan. It seems to be a bank. So the cooperatives are needs interest, yes. The cooperative charges interest for the for those who borrow money from the cooperatives saving and loans. So the legal person or organization with certain qualification treated as if they are natural person. What does it mean? They have rights and obligation. They are liable. They are liable separate from the shareholders. Limited liability company, for example, it is treated as a person, as a natural person. It is liable, and the liability of legal person is separate from its shareholders. Also, the foundation. The foundation is established by the founders. The founders. But the foundation is treated as natural person because the foundation has also a separate financial separate finance, sorry, separate finance from its founder. So is it cooperative? So the legal persons are liable separate from their founders. They are liable. And they can enter into an agreement just as natural person. But who are considered to be capable of entering into an agreement, it depends on the articles of association of each organization. In limited liability company, for example, marketing director maybe maybe authorized to enter into an agreement. Technical director, financial director, for example, So, who are capable of entering into an agreement? It depends on their respective organization. Okay. It is stated in the Articles of Association. Now, 11 o'clock, I think I should stop discussing. And then if you have any question, please keep your question and then ask me on Wednesday. Okay? See you on Wednesday.
Thank you, Prof.
For today's
Thank
session.
you, Prof.
God bless
Thank you.
Have a nice day.
Thank you.
Prof. Have a nice day.
Thank you so much.
Thank you,
See you.
Prof.
Thank you.